All right, so let's move on then to disclosure. Yeah, exactly, Anthony. Get out the tape measure, get it all out. Okay, let's talk about disclosure. We already talked about disclosure in chapter 7, but that was the rule for us, for licensees, people who have a real estate license. What kinds of things do we have to disclose? Now, what we're talking about right here is seller disclosures. Seller disclosures. Well, right away, you should have been like, you ain't getting this past me. You're not fooling me. You already told us sellers don't have to what?
Disclose anything.
Disclose anything.
And that is true. That is true. What if I told you the state of North Carolina was so dumb that we have a law that says sellers don't have to disclose, and we have another law that says sellers have to fill out a disclosure statement? We have both laws at the same time.
That's kind of as bad as the whole provision. That's as bad as the provisional brokers being able to do a dual agency with their broker in charge. Like, it's stupid.
Right. Agreed. So here's the thing. It is possible that caveat emptor can exist at the same time as a law that says the sellers have to fill out a disclosure statement. Here's the catch. And this is what makes this the dumbest law in existence. The sellers have to fill out the form, but they don't have to actually disclose anything. Because I'm going to show you what the form looks like, and then we'll back up. Here's what the form looks like. Look at the answer choices over there on the right-hand side. This is the form. Look at question number 2. Is there any problem, malfunction, or defect with the dwelling's foundation? And they can answer yes to that question. So I'm looking right here. They can answer no to that question. What the heck is this right here?
There's no.
What does no representation mean?
They're not disclosing anything. They don't know.
Well, it doesn't necessarily mean they don't know. It means they're just not going to what?
Say anything.
Disclosure.
They're not going to tell you. So here's the way these two laws work together in North Carolina. That's exactly what it is, Amber. This is pleading the fifth. I'm not answering your questions. I'm following your law. I'm filling out your form. And here are my answers to the questions as the seller.
But why? It just seems like that needs to be fixed.
Well,
it's
that's a question for your state legislature. They write these rules, not me.
So crooked.
So here's the thing. Does this comply with the law that says the seller has to fill out the form?
Yes.
Mm-hmm.
Does it accomplish anything?
No.
Oh.
No. Now, in theory, the form could be useful if the seller answers this. That answer is different than this answer. Does that make sense for everybody?
Yes.
No representation does not mean the same thing as no. No means no, there's not a problem. Could a seller be sued for fraud if they say no and it turns out they knew there was a problem?
Yes.
Yes.
They could be, because that's fraud. They're not allowed to lie.
Mm.
If they know there's a problem and they don't want to say, yes, there's a problem, what should they answer?
No representation.
There's no representation.
What if it's one of them?
What do you mean, what if it's one of them?
Well, that's a whole lot of the slab, the fireplace, the floor. You might have a problem with your floor, but not with your window.
Right. So if it's anything in that list, you're answering for that whole list. Is there any problem with any of the following things? Yes, no, or no representation. Here's the other thing about this form. You're not allowed to help them fill it out at all. You're not allowed to advise them on how to fill it out at all. Your job is to give them the form and make sure that they know they are required to what?
Fill it out.
Fill it out. There are 3 main categories of property that are exempt. These are exempt from needing to fill out the form. So don't expect to see this form if you're making an offer on a foreclosure property or new construction, because it won't be there. Those sellers are exempt from filling it out. Why do you, just from practical purposes, why do you think a foreclosure would be exempt? Because there's nobody to make any disclosures, right? The property's being taken from them. Does that make sense for everybody?
Mm-hmm.
There's nobody to fill out a disclosure. Why would new construction be exempt?
It's brand new.
There shouldn't be anything to what?
Worry about.
To disclose, right?
Yeah, it's new.
Properties being sold as an estate. From a practical purpose, why do you think that's exempt?
Person may be dead.
The person that would be filling out the disclosure is dead. It's hard to get them to tell you anything about the property, right? So these, at least the exemptions make sense from that point of view. But the seller does have the option of checking no representation. We have a responsibility to provide the form and tell the sellers that they're supposed to answer it. Don't ever help them though. Don't ever answer it for them. This is a North Carolina specific form. This is the way we handle property disclosures, and it is a useless form, in my opinion.
Yeah. Do we have the right to look at the form when it's finished?
I'm sorry, what was that, Lou?
Do we have the right to look at the form when it's finished?
We do, and we actually have an obligation really to look at it, because we're going to have to make sure it's available to buyers before they make their offer, because that's who is supposed to ultimately get this form.
Is anything on there a material fact that we would have to consider?
And that's a really great question. So the reason I look over this form is to make sure I didn't miss anything when I was looking for material facts. I don't look at this form in the sense of going, oh, these are the material facts I need to disclose, because I don't want to rely on the seller. Let me be clear. The seller may not be telling the whole truth, or they may not, you know what I'm saying? But if they say there's a problem with something and I didn't notice it, and they put it on the form, yeah, I want to make sure I know about it so I could disclose it. So yes, I am going to review their answers. Okay. Now, let's talk about why it's important in the transaction itself. North Carolina law sets up a penalty for sellers who don't make this form available to buyers before they make an offer. Look at this note right here. It says the buyer should get the form when? Before they make an offer on a property. Even if the seller checks no representation all the way down, they should at least get that before they make their offer, so that they're aware that they're purchasing a property where the seller is just not willing to tell them anything. I mean, if that's all there is to know, that's all there is to know. Seller's not telling me anything. If they don't see it, they being the buyer, if the buyer does not see this form before they make their offer, there's a penalty. And the penalty is not for the buyer, because the buyer is not the one who screwed up. Who screwed up if the buyer doesn't see this form before the buyer makes an offer?
The agent.
The agent.
Yeah, but which agent on which side?
The seller.
The seller's agent, right? And the seller. Because the buyer was supposed to see this thing before they were allowed to make an offer. If the buyer does not see this form before they make an offer, then the buyer gets essentially 3 days to change their mind and terminate or back out of any contract at no penalty whatsoever. So basically, you've given them 3 free days that they could be under contract and get out of it.
Mm. That's the only time that you could get out of your contract, really.
Without any penalty.
Mm-hmm.
Right. So let me give you a hypothetical situation. Let's say that a buyer makes an offer and they say they're willing to pay $25,000 non-refundable to the seller. And the seller accepts their offer and the buyer writes the check. But the buyer never saw this form. 2 days later, could the buyer demand their money back and say, I want out of this contract?
Yes.
Even though the contract says the money is non-refundable.
Yes.
Mm-hmm.
Could they?
If it's 2 days, yeah.
2 days later and they didn't get this form, they sure can. Because that's what this law says. This law says if you don't get the form before you make an offer, you're not going to be held responsible for the first 3 days you're under contract. You get that long to change your mind. So if you think about it from that perspective, whose best interest is it really in from a contract perspective to make sure the buyer sees this form? Is it in the buyer's best interest or is it in the seller's best interest?
Sellers.
Seller.
The sellers, because the last thing the seller wants is the buyer to have these 3 free days to just change their mind and walk away.
And if they never get the form?
If they never get it, they never get it. Past the 3 days, there's no further penalty.
Okay.
The only penalty is the 3 days to change their mind.
And we need to make them aware of that option, that they can, that they got that option of 3 days to terminate any contract.
Not
Yes, you do, and it's actually in any of the standardized contracts you use anyway. It's clearly stated there. There's actually when we look later on at the standardized contracts, there's a box to check. It says, I've not seen the residential property disclosure statement, and I understand I get 3 days to terminate this contract. Or I have seen the residential property disclosure statement. I mean, so it's very clear right there on the contract.
So past that 3 days, it's just like you lost your chance.
That's it. Past that 3 days, it's just like, okay, well, we gave you 3 extra days. How much more do you want? Get out of our face.
It's kind of a dumb form anyways.
Well, that's it. It's a useless form. And so that's why I say if I'm on the listing side, I'm going to make sure the buyer sees it, because I do not want the buyer to have this 3-day free walk away, get off scot-free ability.
Yeah.
And it's 3 days from
Yes.
it's 3 days from when they make their offer.
No, 3 days from the
No?
contract being accepted.
Got it. Okay.
Because an offer can always be canceled. It's 3
It's a
days
good
from
question, though.
when it becomes a contract. Okay. Are we all okay on that, on this law, the North Carolina Residential Property Disclosure Act?
Yes.
Okay. And again, there's the form right there. There's also a separate form that works exactly the same way, called the Mineral Oil and Gas Rights form. And it has to do with whether or not the seller has sold any of the natural exploration rights, like water rights or gas rights, or, rights to, anything that might be underground. And the same rules apply. When should the buyer see it? Before what? Same rules we just talked about. Before they what?
Make an offer.
Before they make an offer. And if they don't see it before they make an offer, they're going to get
3 days.
3
3
days
days
after
after we go under contract to cancel and get all their money back. Okay. That is it for chapter 8, except everybody's favorite, math.
Ooh. Get out your TI calculators.